We all get confused when it comes to whether Indian constitution has federal nature or unitary nature in general. So in order to solve that question, today we are going to understand how India is the combination of both federal and unitary. So in today's video, we are going to understand how that constitution has distributed legislative powers under Article 245, under Article from 245 to 248. So let us first understand about that federal system, which I have just mentioned, whether India has federal nature or unitary nature. India has a federal system. As I said, India both has all the dual system, but it depends on the situation. Powers is divided between the central government and state government, and that makes India a federal nature. So, Constitution divides legislative powers in two ways. So, legislative powers, how can it be divided? So for that it has a process which is mentioned in the Indian Constitution, and that is on the basis of territorial basis, on the basis of subject matter basis. So this is the very true process on what basis the legislative powers can be divided upon the center and the state. Now we'll understand what is territorial jurisdiction. So in general manner, when we say territorial, it means it is about a specific area that we have or a person has certain jurisdiction under. So other than that, he cannot extend or go beyond that particular area. This is mentioned under Article 245. Parliament can make laws for the whole country or any part. So under this territorial jurisdiction or under 245, Parliament can make any laws for the whole country, but the law that has been made, it cannot be applied in other country, for example USA, Australia, because we have a territorial jurisdiction. We cannot extend our power beyond that. It can also make laws for matters outside India, that is extraterritorial, but we also have a exception in this manner. If the nexus between the law and the subject matter and the outcome is beneficial for both of the parties, on such matter the extraterritorial jurisdiction can be applied. States can make laws only for their territories. As I said, state is a very small area. So if Manipur has made some laws for their own state, that cannot be applied in Delhi or Assam or any other state, because it has a particular jurisdiction. So if it's supposed to be for some particular area, that laws cannot be added in other state as well. So that is the very definition of what territorial jurisdiction is under 245, and what parliament can do under it, what state can do under this. Now let us move into the extraterritorial state law, which I have just given a hint. Generally, a state law is invalid if it applies outside its territory. As I said, if a law is for Manipur, it cannot be applied in Assam. That is invalid. However, there is an exception, but it has an exception. If there is a strong and genuine connection called sufficient nexus between the object of the law and the state, then the law can still be valid. But as I said, if the law is beneficial for both of the state and it has sufficient nexus, then it can be declared as valid. This was clarified in the case of State of Bombay versus R.M.D.C. in 1957. So this case I have already been discussed in my other video. You can go and check it out and get a broader view about what this case is all about. So extraterritorial state laws, and regarding this manner, this case has a very important role to play, and this is an exception. Now let's move into what is subject matter jurisdiction. As we all know, subject is all about a particular subject. It's not like mathematics, geography, that is also a subject, but here the subject means a particular topic. For example, education, health, marriage, these are kind of a particular subject. Now we will understand how the Indian constitution has divided legislative powers between the state and the center based on the subject matter jurisdiction. So basically, constitution has three in the 7th schedule. So here will come the 7th schedule, which plays a very important role when it comes to the distribution of legislative powers between the union and the state. And we have three lists in this manner. We don't have more than three lists. The first one is union list, where center makes law. So what are the subjects that have been wasted upon union list? On that basis, center will make law on list. For example, if Indian list has the concept of marriage, so regarding marriage, what should be its essential, how can one go and opt for it, relating to all kind of necessary information. Only the center has the right to make laws upon it. That's said, the state cannot interfere in making those laws, because under the state list, the subject matter, that is marriage, is not mentioned. So marriage is all for the center only. It is vested for center. So only the center has the right to make laws over marriage. Now we have state list. States make laws. For example, under state we have the topic education. So the state will make laws regarding education. What should be the limit? What should be the fees? What should be the criteria? All these responsibilities have been vested upon the state list only. So state has the right to make laws upon this particular topic. So in this manner, both has similar powers, like on what basis they can make laws upon. Now let's come about concurrently. So what about this particular? So for example, if any subject matter left behind, for example, liquor is the topic which is not mentioned both in union list and state list. So what will happen in this manner? Would that be left out? No, it is also a very important topic which should be covered. So all the subject which has been left behind will be added directly in the concurrent list, and both can make laws on whatever subject matter is listed upon concurrent list. It is open for both the center and the state. They can make laws on the subject matter that is mentioned under concurrent list. Now let us come to conflict between laws. So for example, the state laws and central laws, it has a specific subject matter, and it is said very clearly that these are the subject and the union can make laws, and these are the subject and the state can make laws. But what about the concurrent list? Because concurrent list is open for both of the parties. So if the center is making a particular law on liquor, the state can also make a particular law on that liquor. So what will happen in that manner if there is a conflict between both of the law? For example, state has make a law by stating that if you go to school, I mean, if you go to school, and that is mandatory, you have to go to school. So it is the laws made by the center. And the state has made a law that going to school is punishable. So that is a conflicting statement that is given by both center and the state. So what will do the general public in that manner? If they go to school, they can get punished. If they don't go to school, then also they get punished. So what will they do in such conflict situation? So in this manner, when both parliament and state legislature make laws on the same subject in the concurrent list, and there is a conflict, the union law will prevail. So here what happened? The center is powerful. So if there is a conflict between the laws in such manner, the law that has been made by the center, that will prevail. So what if there is no conflict? For example, the center has said that going school is mandatory, and state has said that going school with a bag is mandatory. So in this manner, there is no conflict between both of the laws. So in such manner, both of the law can work continuously because there is no conflict between both of them. But if it's contradictory to both of the laws, in such manner, the center law will be applicable. However, if a state law has been reserved the president's assent and gets approved, it will override the union law in that particular state. But it has an exception also. If the state law has been reserved for the president's assent and get approved, then for that specific area, the union law in that particular state, it will override the union law in that particular state. So this is the very exception that is given here. Now let us move into what is residuary powers under Article 248. So there is very much possibility to come residuary powers as short notes in many of the exams. So in this through this short paragraph, you will understand what is residuary powers. Article 248 gives Parliament the power to make laws on subject not mentioned in any of the three lists. So here I have already said the subject matter mentioned upon union list, subject matter mentioned upon state list, the subject which is left behind will be added in the concurrent list. What about the other subject that is not covered by both of the three lists? So in that manner, the residuary powers comes in place. So it says that Parliament Article 248 gives Parliament the power to make laws on subject not mentioned in any of the three lists. So in such manner, if any particular topic pops up, and for example agriculture is not covered by both of the three lists. So in that manner, the Parliament has the right to make laws on this particular topic. It has been given wide power, and that has been clarified by Article 240. These are known as residuary powers. Unlike India, countries like the USA and Australia give this power to the state. So USA and Australia has given their power to the state only. State have the residuary powers and they can make laws. But in India, the parliament has wide powers and they can only make laws on the subject matter that is not covered by all the three lists. So in this manner, we have a very important case law, that is State of Karnataka versus Union of India in the year of 1978. The Supreme Court confirmed that Parliament has wide powers under this article. So this article has clarified it, that the Parliament has wide powers under this article, and if any topic pops up which is not covered by all the other lists, then the Parliament can make laws by using residuary powers. And that is the very definition of what residuary powers is and who are the people who can use this power. So now we will understand some of the important case laws regarding this, like distribution of legislative power. So when we talk about constitutional law, when we talk about law, the case laws plays a very important role. So if you don't add any of the case laws while writing an exam, there is probability you will score very less marks. So we have to always refer to certain case law and the judgment given by the courts. So now let us understand the case law they have mentioned. The Supreme Court at International Tourism Corporation versus State of Haryana in the year of 1981 advised that residuary power should not be used frequently. Whether it has said that residuary powers is already there, but the court advised not to use it too frequently. If there is no need to use it, if there is no need of the hour, then it should not be used. Then we have in Chandrasekhar Patra versus Jiten Manki in the year of 2017. It was held that central laws override state laws in case of conflict, which we have already discussed. So while writing what will happen if there is a conflict between state law and central law, this case law can be referred. Overall, the Constitution provides a clear framework for distributing legislative powers to maintain harmony between the center and the state. So the powers have been already distributed using a very fine framework, using the 7th schedule, using the all still list, adding the residuary powers. So this is all about how Indian constitution has added certain articles on what basis the powers would be divided between the center and the state, which I have tried to cover it using all kind of necessary information which will lead to more detailed understanding of this very topic. So that's all about how the powers has been distributed. So if you find this video worth watching, do like and subscribe. We will soon meeting with just legal updates. Till then, stay happy, stay healthy. Thank you for watching the video.